Hi, my name is Tim Zerillo, and I'm broadcasting and making this video on March 12th, 2012 at Zerillo Law LLC in our offices in Portland, Maine, at 103 Exchange Street. Thanks for watching. This is part of our criminal defense series, and I want to talk to you today very briefly about an extremely complicated subject, and that is the subject of domestic violence charges and gun ownership. Now, most people realize that that a domestic assault conviction or that a felony conviction rather will prohibit you from possessing firearms. It's a lifetime ban. But many people don't know that a domestic assault conviction will also prohibit you from possessing firearms by virtue of a federal law. Now, this is an extremely complicated subject. I lectured about this topic to a group of lawyers in October in York County, in the York County and Cumberland County Bar Association, and I'm scheduled to lecture to lawyers on the same topic at the Maine Association of Criminal Defense Lawyers annual meeting in June of 2012. As I say, it's extremely complicated, but you have to be wary of it. So my first tip here is just to be wary of it. If you care at all about gun possession, gun ownership, and you're facing a domestic assault charge, you have to be very careful. I can tell you right off the bat that if you are convicted of a domestic assault charge, that you have some significant trouble. But there are gray areas that need to be analyzed in each case. Let's say, for the sake of argument, that you were facing a domestic assault charge and you were given given a deal to enter into a deferred disposition. A deferred disposition is usually a good deal in most criminal cases, and what it does is it requires that the person plead guilty to a certain charge, go through a certain period of time, and do certain things, and then at the end of that time period, the charge usually changes to something else or is dismissed entirely. So let's say, for the sake of argument, you had a domestic assault charge, and you had a deferred disposition agreement, and at the end of that deferred disposition agreement, let's say for a year, the domestic assault will go away. Well, what happens during the course of that year, for example? Are you able to possess firearms during the year? There is some disagreement on this topic because it's very complicated. I think to be wary, you have to really analyze each of these things on a case-by-case basis. Here's another area where there has been a lot of trouble in recent years, especially with lawyers perhaps practicing criminal law when they shouldn't be, or with younger lawyers. If you have a domestic assault charge and the prosecutor offers to drop it down to a simple assault, non-domestic, in other words, strike from the complaint the domestic assault language, you would think that that would allow you to possess firearms, but it does not, because the federal government can look beyond that charging instrument, or the instrument that says what you are convicted of, and can look to what the original facts of the case were, and they can use that to say that you no longer possess firearms. Which is all to say, and this is a complicated topic, my talk on this is a lot longer than a couple of minutes on a video. The point is this: you have to be very careful, and you have to be very wary if you care about firearms when you're charged with a domestic assault. I call domestic assaults, even when they're misdemeanors, I think they're junior felonies, because they have some real felony type consequences to them. So that's just a little bit on this topic. Of course, if you're facing a domestic assault charge, you can feel free to call me or any of my lawyers who work at Zerillo Law LLC. All are very qualified to handle these types of cases. Our number is 207-347-6063, 207-347-6063, or you can email me directly, tim@getzerillo.com. That's tim@getzerillo.com. Thanks for watching.